Hi, everyone. Thank you for joining us today. We'll give it a second for everyone to get in. Okay, let's see, 12 o'clock. Okay, guys, I am Sarah Moran, Program Coordinator with the Contra Costa County Bar Association. Thank you guys for joining us today for this program on the art of bracketing that is being sponsored by the ADR section. I wanted to mention a few things on my end. You will receive your attendance certificate and materials within the next week via email, so keep an eye out on that for that. You can enable closed captioning on the bottom of your screen if you want to. And if you have any questions, please put it in the chat or in the Q&A, and the presenters will handle those at the end. But if they pop into your mind, you can insert those at any time. And I also wanted to mention a couple upcoming programs with the Bar Association. If you haven't heard, we have our gala coming up on April 13th. It's the 90th anniversary celebration of the Bar Association at Black Hawk Museum in Danville, which is going to be really fun, really exciting. So we hope to see everyone there. And let's see, we have our women's section annual luncheon on the 21st, and we have Judge Young presenting. So that's always a fun event to see everyone at. And then let me see if there's anything else. I think that's it for you for this crowd. If you're a member of the ADR section, keep an eye out because we'll have some more programs coming up soon. And I'll go ahead and turn it over. Let's see, we have Patricia Prince here today, Tia Maerz, Carrie Levine, and Diana Meyer, all here to do a great presentation today. So I'll turn it over to Diana, who's going to do a quick intro on all our speakers. Thank you, guys.
Thank you so much, Sarah. So I'll start out and do our introductions and then talk a little bit about why our topic today, and then let the panelists get into it. So I'm Diana Mayer. I have a firm in Marin County Mayer Law Group. We do employment law. Of course, my specialty these days is mediations, employment law, and then some business, estate planning, other kinds of disputes as well. I sit on the Northern District Court panel, which is where I met all these lovely women, and a number of other panels as well. The people that are speaking with you today, I have Carrie Levine, who is with Erickson Levine Law, and Carrie began mediating matters full-time after about 20 years as a trial attorney, first as a deputy district attorney in LA, and then as a partner for 20 years combined at both Jones Day and Seyfarth Shaw. And Kari also mediates business, employment, insurance, and ADA access matters. Tia Welch Maerz is with Essential Law Group, also obviously a mediator. She's been an appointed neutral for the Northern District Court of California since 2008, and she became a lawyer because she really wanted to focus her practice in the classroom, in the courtroom, and not the classroom. And her career started as the trial deputy for the San Francisco City Attorney's Office. And then she became a founding partner at 2 San Francisco boutique litigation firms. She now mediates full-time. And then finally, Patricia Prince of Prince Law and Mediation specializes in the resolution of business and employment disputes. And she started practicing law as a business litigator in '91, became a full-time mediator in 2007. She also mediates, like the rest of us, employment disputes, and then including discrimination, retaliation, wrongful termination, wage and hour cases, as well as business and intellectual property disputes. She is fluent in Spanish and enjoys meeting with Spanish-speaking parties. So why this topic? Well, I have long been an advocate of bracketing, using bracketing in mediations for a number of reasons, some of which we're going to talk about today, but things like expediency, uh, kind of opening up a new part of the brain, a more creative strain when things are getting impasse to impasse. And I am a big fan of it. And I also, like a lot of attorneys and mediators, have found it very confusing at times. And there are often times when I want to encourage attorneys to use it, and I will get a bit of pushback with this idea that, oh, I don't really understand brackets. So, and that can be anything from, who has the next move? Are we dealing with here with a range or a specific number? When should we use it? Do we openly call it brackets, or is there more of a stealth technique involved behind it? And then are the numbers that we use, if say we're talking about a range, are those the mediator's numbers, or do we use one of the lawyer's numbers to start? So we're going to talk about all of that today. I wanted to also briefly say, what are brackets? And really, it's more about what brackets are not, which is, I think, the easiest way to define it, which is they're not a specific demand or offer like the way we often do in mediation, where one person puts a number out and the other person responds. So instead, it sets a range within which parties can negotiate. And you'll also see that for each of these three mediators who I call upon, they use brackets in different ways. They may call it different things. They may start out with it, or they may go into it much later in the mediation. So they're going to talk about the different ways they use brackets to make it an effective tool in it, but also a painless tool after you've completed this talk today. So the first thing we're going to talk about is how, when, and why people use brackets, or mediators use brackets. And Kari, I wondered if you could start out with answering that question for us.
Great. Thank you, Diana, and thank you to the Bar Association for hosting us and those of you that are joining us. It's interesting, as you'll hear today, all of us use bracketing somewhat differently, but I think when anybody thinks of bracketing, the first thing you think of is something to use from a toolbox when things aren't moving. And the when and why I use it is easy and comes way before that. And I'll explain what I mean by that. The work for me is in how I use them, because I generally use brackets without calling it brackets, and I come up with the numbers without the parties actually understanding that I'm coming up with the numbers. And that probably sounds very confusing. So here's how I'll explain it. I find, first of all, the first discussions about money for me usually occur a few hours into mediation and always in private caucus, almost always. And I'm finding more and more in the cases I mediate that the parties, even though they've been collaboratively discussing the facts and the case and working, and oftentimes have spent a lot of time with me in joint session together, suddenly when they want to go to money, they want to start both sides in a place that puts the parties further apart than they were before they came into mediation. And so my work, and the reason I use brackets in that situation, is to help the parties understand, first of all, if they want to resolve the case, and if that is their intention, and if they want to communicate to the other side that they want to work collaboratively to reach that goal, then I try and get the parties to see how the numbers are actually communicating a larger message, a more important message than any of the work we've done up to that point. And so I work with the parties to dissect the issue of the number together under joint attention, so that it kind of helps them see what the message is and what they're going to do with the number they communicate. And I try and get them off of the numbers to understand that where you begin is truly monopoly money, and that much more than the number is the import of the message. And that, the last thing people want to do is piss off the other side and drive the parties further apart at hour 2 or 3. So I'll use the concept of bracketing by help me in this room, help you reach your goal. And what is the number that you're proposing initially going to say to the other side? And if you don't like what it's going to say, how can we change that? How can we fix that? And I'll do that in both rooms, and really build on the theme that we'll talk about. And you'll hear both Tia and Patricia mention the theme of trust. You really have to trust me that I know what I'm doing, in order to understand why I'm trying to get you to a different number and bid against yourself before you've even started negotiations. So that's when I most often use brackets, in the very beginning at the first monetary discussions.
Great, thank you, Corey. Patricia, can you talk a little bit about your use of brackets?
Sure, thank you. It's lovely to be here today. I really like the way Kari highlighted trust. I think it's a really essential element to the use of successful bracketing. When I am most likely to suggest bracketing is after I've worked with the parties, and we've discussed the factual and the legal issues, and they have sent single numbers back and forth with offers and demands. And then at some point they hit impasse, typically because they've come to believe that the gap between their respective positions is larger than it actually may be. And so I think bracketing is a really lovely way of breaking through that. And there are a couple of situations where I think bracketing is particularly helpful. One is when the parties are stuck in an unworkable range because one party has anchored their offer demand too high or too low. And I think bracketing is a great way of really broadening the focus, and helping people think about hypotheticals that in a way that allows people to reset that unworkable range, and really reassess what the zone of potential settlement might be. Another time when I immediately reach for bracketing is when there's an impasse, the gap is fairly large and the parties are starting to get frustrated with each other, and they're sending punitive offers and demands back and forth as opposed to constructive demands that are really moving the ball forward toward a settlement. I think bracketing is a great way of disrupting that type of unproductive pattern. And bracketing does that by giving both sides more information about what might be possible with different reciprocal moves. So how I use bracketing is always in caucus. My strong preference is to have the parties and counsel generate the actual bracket. And I always, start by the full explanation, including the fact that, you'll be using a conditional range, and I'll be taking that to the other room. I will explain to the other room that if you come to X, they will come to Y. And I also point out that I remind everyone that they are conveying a great deal of information, the endpoints of the bracket, as well as an implied midpoint. That implied midpoint is important to keep in mind, but it will move because all numbers in a negotiation move. I then go through the different responses that the other room could have to the proposed bracket, and whose turn it would be depending on which response is chosen. So I go through all those things so that everyone understands how I bracket, because we all do that a little bit differently. The why of I reach for bracketing, why I use bracketing or suggest it, is just to keep the negotiation moving forward productively and effectively.
Great, thank you, Patricia. Tia, would you talk a little bit about the why of using brackets?
Sarah, thanks for inviting us. Happy to be here. And Diana, thank you for the introduction. I'm going to talk a little bit more about why I think bracketing is a great tool for negotiation and mediation. And there's really 2 points I want to make. It's a safer way to communicate. And secondly, it really has the potential to refocus attention. And what I mean by a safer way to communicate is because bracketed negotiations are conditional. So in a typical firm offer, firm demand situation, somebody might demand $1 million and the defendant might offer 20,000 in settlement. Those are firm numbers. There's no getting away from that, and that is the status of the negotiations at that point. However, if you're using bracketed negotiations, it's conditional, meaning, okay, I might say to one party or the other, if I can, let's say I'm saying it to the defendant, if I can get the plaintiff to drop that demand to $750,000, would you be willing to increase your offer of settlement from 20,000, 50,000? And it's a safer way to communicate, because if it's not accepted, you're not committed to anything. Whereas obviously in a firm demand or a firm offer, you are stuck at that number. You're committed to that number. And it really says to the other side, I'll play if you'll play. And so, you know, because it's contingent, it gives more flexibility to the parties. And that's what I mean by safer way to communicate. The second point about refocusing attention is kind of by definition, when you come up with bracketed negotiations, the party necessarily has to think of how their proposed bracket is going to land on the other side. And what that does is it creates a fluidity, because they now have to think how their proposal is going to land on the other side. They're not so fixed on their number, and maybe, you know, maybe they want to come up a little bit, or whatever it is they're communicating. But by definition and necessarily, you have to think of the effect on the other side and what their potential response can be. And so for that reason alone, it kind of shakes up the thinking, because it is collaborative, and it gets the parties to start thinking about, okay, well, if I can do this and the other side can do this, then now we're kind of in a collaborative problem-solving scenario. So I like that fluidity. I think it has great potential for settlement. Two final brief points about how I use it. I typically don't use it until the parties have kind of hashed out traditional firm offer and firm demands and experienced a little bit of frustration perhaps. And I always bring it up in private caucus. And I typically allow the parties to craft their own proposals, unless they ask me for some guidance, and I probably wouldn't feel comfortable doing that until I've heard from them quite a bit and hashed out the facts and the law and see how they see it.
Right. Thank you so much. So a couple of points I wanted to highlight from what the three of you said, particularly the differences that Kari focuses a lot on, or focused at least here on, the idea of using brackets as a first step out of the gate, when the numbers, asking the parties to think about the numbers they're going to put on the table and the message that it's going to send, and is it going to get that party where they want to go? What's that message going to send to the other side, and is that the message that they intend to send? So sort of looking at those numbers as not hard and fast numbers, but starting points from which to discuss where the parties are looking to go. And then Patricia talked about using it maybe a little further along in the process when there is an impasse, possibly, or the gap between the numbers just seems really large and there's some loss of patience. And she discussed the idea of using the how of using it as sort of a, oh, this is a different approach that we can try, and also explaining to the parties what it is, that it's conditional. If you go to X, then I'll go to Y. And so allows parties to negotiate with some safety in that area. And then Tia talked a lot about the why. So the one of the chief whys, which behind why she uses brackets, is to consider it as a safer way to communicate among the parties. So it's conditional. There's no firm. I'm at this number. You're at that number, and that it can really refocus the attention to come back to the issue at hand, and look at how the numbers that that party is thinking about sending out, how that's going to land on the other side. So again, refocusing away from just this sort of myopic, insular look to also thinking about the other side and what that's going to communicate to the other side and what one might get back in response to that. The next thing I wanted to ask you about, and sort of tagging on a little bit with what Tia talked about here, but maybe getting into with a little bit more depth, are the overall benefits of using them. So the why that you find that are the most important pieces of when you would introduce brackets. And Patricia, perhaps you could start by talking to that area of what are the benefits that you see.
I'd be happy to. Bracketing has a number of wonderful benefits. I'm going to talk about three: signaling, transparency, and efficiency. So bracketing is really a lovely way of signaling movement potential. And it does that by helping the parties and counsel test and then reset assumptions that they are making about the other side's willingness to reach an acceptable number. And if you can test and reset and create movement, that creates hope, and again, you get to the end result a little bit faster. Transparency is another great benefit, and by that I mean there is you can increase visibility of the zone of potential settlement with brackets. That is particularly helpful when the parties are stuck in a posturing mode and you have numbers out here on the end, and they're not real numbers. So I think bracketing can be a really great way of helping both sides put their best numbers on the table to evaluate. And then efficiency. Bracketing can also be very helpful in shortcutting a long negotiation dance when it's just taking too long. So it can be very efficient and thereby reduce frustration, which again is helpful. And so I wanted to give you just an example of a fairly recent mediation that I did that demonstrated how these benefits can be realized. I was working with two parties that I had been working with most of the day. We'd gone back and forth with all sorts of single number negotiations. We had discussed all the factual and legal issues. And finally, we hit impasse. And in the plaintiff's room, I was hearing, don't ask us to make another big move because defendants just really aren't putting serious money on the table. We don't think they're here in good faith. Meanwhile, in the defense room, I was hearing, yeah, we could move more, but we're constrained in the amount of money we can put on the table at this time because plaintiffs have anchored in the stratosphere. We just don't have a workable range here. So in the plaintiff's room, I suggested that, would you consider bracketing? And after discussion of the hypothetical moves and what might be possible, going through the process so that everyone was on the same page as to how it would be used, plaintiffs agreed that that might be helpful. They might signal the movement potential with a new range, because in fact they would be willing to move significantly if and only if, to Tia's point, the defendant came up to and put a more substantial number on the table. So I left. They came up with a bracket. I then took that back to the defense room, and as sometimes happens, defense counsel said to me, "Oh, no, 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 I never use bracketing." Sorry, no go. But I think the thing that is so great about this is that it didn't matter that the defense counsel didn't want to go back with a bracket, because what had happened was plaintiff had demonstrated good faith by putting forth this bracket, and defendant now understood, because they had that greater visibility of the potential zone of settlement, that in fact, he was making assumptions about where they were that weren't true. And so defendant thought, this is great. I want to acknowledge that, that move and the message they're sending. So it wanted to reciprocate. The defendants decided that what they would do is look at the implied midpoint and respond with a single number back to plaintiff, but based on that midpoint. And then, of course, I went in and underlined their reasoning, how they were looking at that implied midpoint, and that they were responding to that with a much bigger number. I presented that to plaintiffs, who again also saw the goodwill in that. They were mistaken as to the original range. And just by making visible what was possible, it really reestablished hope and reset the settlement negotiations in a way that allowed them to get to a number they could both say yes to.
Great. Thank you, Patricia. And Tia, can you talk a little bit about the benefits that you see, maybe elaborate a little bit on what you discussed earlier?
I think the number one benefit is it's a tool that can really increase the potential for settlement that day. And I think it does that by doing two things. One of them is it can really boost confidence in the process that your case will settle that day. And it can be a vehicle for more productive and meaningful communications. And most people that I talk to, when they attend a mediation, of course, you can't be guaranteed of the outcome, but if you have productive and meaningful communications, even if the case doesn't settle that day, you've exchanged information that may make it more likely that it could settle within the next few weeks if a piece of information is missing. And secondly, there's a sense of fairness, I think, that can be a real benefit. So I also think that one of the benefits of bracketed negotiations is that it can prevent premature termination of negotiations. When parties feel like they can get stalled out and they want to walk, bracketed negotiations can keep the parties engaged and continue to negotiate, which is always a better alternative than simply walking away. Those are the two primary benefits that I've seen. When we talk about a little more detail about midpoints, I'll get with more detail about that later.
Okay, thank you. Kari, would you talk a little bit about what you see as the key benefits?
So I love the points that Tia and Patricia have both raised, that predictability, that you get transparency, you also continue movement throughout the day. And I find whether I use brackets in the beginning, whether I use them when things have stalled, whether I introduce them and leave them, which we'll talk about in a bit here, I think the most important thing that I always see is that it frees up creativity. Because I hate it when the mediation is just these dry numbers going back and forth, because frustration levels increase dramatically when things get dry, and it then brings out the lawyers. I hate to say that, but the part of the mediation to me that's most important are the clients. And oftentimes the lawyers overshadow the clients. And when you're just talking money back and forth, I find that is the key area where clients get overshadowed. And yet it is the most important where the clients are heard. So for me, bracketing integrates the clients, because everybody starts thinking about, well, why are they doing A and B? And, you know, why is their range that? And wait a second, they used to be at this and we moved to that. So it just adds things in the room that create a dynamic that there's free flowing thought once again. And it also, to me, once again, and we've all mentioned it, messaging, 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 and trust. That brackets are sending messages, and oftentimes they're not the messages intended. And so bracketing requires the parties to slow down and really understand where they actually want to go at the end of the day, rather than all the focus being on where the other room, what the other room is doing. And it brings them back to, well, do we really want to end up in this place, or do we have more flexibility, and how do we communicate that without giving away, you know, anything that we didn't intend to signal at this point in the day? So for me, those two things are the most important: integrating the clients and really looking at messaging from your own room, as opposed to just the focus always being on what the other side is doing and how can we victimize them.
Great. And I like that idea about requiring the parties to slow down, because, you know, when I do get this pushback around, well, I don't really understand them or whatnot, you know, that actually can be a good thing, because it takes a while sometimes for the parties to really know how they're going to use them. And it does take sometimes the mediator stepping in and explaining things. But all three of you had great things to say. I heard from Patricia, the benefits were threefold: that signaling, so showing that there's movement potential, even if you're not there quite yet. And then transparency. So with some specific numbers in their range, at least, as opposed to just kind of a pie in the sky number that, you know, the case is not going to settle for. And then, of course, efficiency. So keeping the the momentum going, and keeping the range to be more of a realistic one. Excuse me. For Tia, I thought that that your 2 points about fairness and preventing premature, you know, termination of the brackets, that brackets can be turned to when things otherwise might look like they're in trouble, or the parties don't know where to go, that they can really increase the ability to have settlement that day. Or alternatively, just set things up really well to settle fairly quickly after that day. And then, Kari, I love what you said about just really freeing up creativity and integrating, having the client start to think about their range and the range of the other side. And that there is a message of trust, and also a requirement that parties slow down when they want to use it. That can be a really positive thing in a mediation, instead of just kind of numbers going back and forth. Requires the parties, and not just the attorneys, to get involved and think about what where they want to go from here, and what the other side is telling them about where they want to go. I wanted to talk about one thing that I have found to be problematic when I propose the use of brackets at times. And that can be this kind of fixation and almost paralysis sometimes around the midpoint, that, you know, oh, before a bracket is offered, you know, well, I go here, and that if I give them this range and that range, well, the midpoint's this. And so not wanting to make any kind of a move unless what the midpoint is calculated at is the right midpoint, and sort of this assumption that the midpoint is where the parties are going to end up, even though that may not be the case at all. So Tia, would you start by talking a little bit about that and how you deal with that issue?
Yes, I think the reason why attorneys have a big reaction if there is a proposal for a bracketed negotiation is because of what we've been calling the midpoint paralysis, or midpoint fixation. And in the example, I'm going to give an example. So say we had parties that started with $1 million demand and a $20,000 offer. And then we had a proposal for a bracket of the plaintiffs would come down to $750,000 if the defendants made an offer of $50,000. And in that situation, I think the terminology that we've been using, I'm going to go ahead and define it because sometimes people use different things, different terms. But what we've been talking about, the explicit endpoints in that bracketed negotiation would be the $750,000 and the $50,000. Those are expressed by the defendant, $50,000 by the defendant and $750,000 by the plaintiff. The range would be the number between those two, so it's that's a $700,000 range. Still, of course, not a bridgeable gap, but better than $1 million and 20,000. And then this implied midpoint that we've been talking about. So the way that you calculate the implied midpoint is by taking the 750,000 and subtracting the 50,000. That gets you to 700,000. And then dividing it in half, which is 350,000. And then you would add that to the bottom number. And that's 400,000. And that is the paralysis point. So the way that I usually address it is to acknowledge it and say, look, we're in this bracket that does not mean the case is going to settle for 400,000 and that moves are going to bring it to 400,000. And I think referring back to the example that Patricia gave, that's a reason why a lot of defense counsel are frankly reluctant to respond or to engage in bracketing because they think it's going to be like a dollar for dollar move towards that midpoint, and they're not going to do that. So I usually acknowledge it and say, it's there, it's human nature to fixate on it, but I want you to repeat, I accept this range of settlement. I do not accept the midpoint. Because the potential really is that you're seeing the possibility. What you're saying is, okay, I can see the potential for this case to settle today somewhere between $750,000 and $50,000. And that's all you're saying. Now, having said that, there are 2 or 3 traps that I think you should try to avoid. One of them is, don't propose or agree to a bracket that's really, really near your best number for that day. So in that example that I gave, if, for instance, the plaintiff's absolute bottom number that day is 700,000, do not agree to a range of a top number of 750,000 because that doesn't give you any room to move. And likewise, from the defense point of view, if there is a $50,000 demand and your top dollar is 55,000, you can understand how that would result in a lot of miscommunication and hurt feelings and accusations of bad faith. So that's my number one tip to avoid. Well, I guess I have 3 tips. Number 1, acknowledge the midpoint fixation. Number 2, don't propose or accept a bracket that is just too near your best number for that day. And number 3, be prepared and talk through the potentialities, the eventualities more than once, and take your time talking through them because you should always be discussing how it's going to land on the other side, and you should always be looking at the messaging that you're sending to the other side with the brackets that are being proposed. It's an imperfect device, but it gets you information that you otherwise might not have had access to. And even if it's not accepted, it's some great information. As Patricia said, her party responded with a firm offer. They took the midpoint into consideration.
Right. Patricia, can you talk a little bit to the issue of midpoint and midpoint paralysis?
I think certainly I love Tia's point that you can't, you need to be aware of it, but it's not something that that needs to stop the negotiation. And I think the key thing for me is just make sure that by keeping it in mind that you are thinking about how will it be perceived in the other room, and will they feel that you're putting up a number when on the next move they then feel sandbagged. So again, being mindful of what it is, I think is important, but every member is going to move. So I really like to emphasize that. Remember, we're moving towards settlement, so things will move. One thing about that plays into midpoints is what I call strategic ambiguity. And that to me is a great tool that bracket provides for people trying to get to yes. The strategic ambiguity comes into play because bracketing has a lot of moving parts, and that's fabulous. You have the two stated endpoints, you have an implied midpoint, you have the breadth of the range, it can be wide, it can be narrow, you have the size of your moves overall, and then you also have verbal messaging that the mediator can add to really highlight any one of those elements, because what you're really trying to do is, again, establish that forward movement towards an acceptable number. I always say, go to war with the army you've got. Think about all those elements. What can you use? What can you shift attention to be more positive, so that the other side sees movement and will respond with movement? I wanted to take a couple minutes to talk about math and concerns that bracketing may be too complicated. And my bottom line is embrace the math. It's not that difficult. You can use a sheet of paper and do a zigzag diagram to help you see the movement. You can create shortcuts for yourself. So since I started mediating, have used Excel spreadsheets. I've always liked them as a way to capture the moves of the party. I can automatically calculate that movement, and I can do the same with bracketing. So, and there are many online applications now that help with figuring out negotiations and the math. So, create shortcuts if you need them. They can be helpful. I also wanted to underscore one of Tia's points about, taking the time. I always use the adage, measure twice, cut once. I think that once people start using bracketing, what typically happens is I will spend a lot of time in caucus with one room talking about the possibilities, exploring, general numbers, and then I will leave, and the party and council will come up with the exact bracket that they want me to propose. I come back in and they send me out immediately because they want to get that number to the other side. They want to send me out. And I always remind people, look, let's just take a beat. Let's take a second and reconsider this final bracket that you've come up with. Let's look at how all those strategically ambiguous parts have moved, and think about, how will that impact? How have you moved from your last move? How does it compare to this other side's last move? And do you leave yourself enough room to move the next time it comes back to you? Then flip the consideration and think about, how will it look to the other side? Have I provided enough incentive for the other side to give me a move back, a bracket back, or a move that will be appealing? So I think that's a really important point to emphasize. And finally, ask for input from your mediator. Most of us mediators are not shy about providing our opinion as to a bracket and trying to shift things a little bit in a way that we think will be more productive. But if your mediator is not providing that advice, do it. We're sitting in both rooms. We have a lot of very valuable information, and although we typically don't know the specific number where the case will settle, what we do know is how your proposed bracket will be received in the other room generally.
Thank you, Patricia. Corey, can you talk slightly about midpoint fixation and strategies you might use to work with?
Well, I love when both, Patricia and Tia start talking numbers. And embrace the math, because I hate it when the parties start doing the math. When calculators come out, I think my biggest skill as a mediator that I've learned from those who came before me and from just handling lots of cases over the years is keep my intuition like peeled and make sure that flexibility doesn't lose, the process doesn't lose its flexibility. And I find, people will talk about are mediators evaluative or not. I try never to be evaluating the facts and who's going to lose, who's going to win, but I'm extremely evaluative when it comes to helping the parties increase the options. So for instance, a party says, okay, that's it, we're done. And I'll go, oh, okay, that's one option. Can you think of some other options? I do that with brackets too, because oftentimes I like to be the one suggesting, if I can do this for you in the other room, what can you do for me to show them the same good faith? And then I'll leave them with that concept. Think on that. Like, where do you want me to get them? And how are you going to help me do it? And oftentimes that gets, at least I find, parties off of I don't want to into, well, can you do this for me? And if you do this for me, I can give them this in return. And it starts moving those top and bottom numbers. And I find that when those are moving, there's less fixation on the midpoint. When parties get fixated on midpoints, or I see those calculators come out, that's my signal, do something different. And I'll completely leave the math for a minute and start asking lots of what if questions. And I'll also play a game with the parties, which I find parties hate to begin with, and then they really get into, which is the villain, victim, hero triangle. In other words, I'll pass out slips of paper to everybody in each room and say, as I leave you, I want you to do this exercise. Tell me from the perspective of the plaintiff in the other room or the defendant in the other room, what is their story? How are they looking at this case? What are they feeling? What are they thinking? And, how are those thoughts and feelings and underlying interest leading to the number that you were stuck at a few minutes ago? And oftentimes it takes doing it 3 or 4 times, because first they're like, they're all wrong. They're nasty. They are going to lose. And then the second time it'll be, well, okay, maybe they'll look at them from the perspective of a victim. They don't get it. They just don't understand the law. And then finally, when parties get into the perspective of, okay, from their side, I can see that they see these following things, although they see the world in a different way than I do. And once I get the parties there, the numbers start moving again, because people have understood the world from the eyes of the other room, and therefore what it's going to take. So it's just a different way of doing the exercise of what if, and if I get you X, can you give me to give them Y? So that's kind of what I do with the fixation on the numbers.
Right. So thank you. This gave me some really good ideas on working with midpoint paralysis. One of the things that Tia talked to was, acknowledging the midpoint, but not sort of accepting that, having a party say, or having the mediator give the message that the midpoint is not necessarily the number that will be the actual kind of final number, or the number that the case would settle at, and then talk through eventualities. And then Patricia talked a little bit about keeping the midpoint in mind, to enough so that there is a sense of where things may go, and actually to embrace the math. And one of the things Patricia can talk about or show us at some point, send out, is a spreadsheet she uses, which will talk about the defendant has gone here and the plaintiff has gone here, you know, what's the percentage move that they've made from what was their increase or decrease, and what is the midpoint, just so that these numbers are tracked, even while acknowledging that that is not necessarily where the mediation may end up. And then finally, Kari talked a lot about using this idea of kind of the villain, victim, hero triangle, or really asking the parties to role play what's the other side thinking, and really consider what the story is of the other side, to sort of get out of just looking at the numbers and kind of looking at the broader considerations of, you know, what the other side is dealing with and where they may go from here, and what their story is, that, you know, about what's going on in that particular moment. Finally, I wanted to ask each of you if there is sort of one final thing, one issue with that you see a lot with bracketing, that you want to discuss or speak to before I go to some of the questions that we have in the chat. So let's see. Patricia, why don't we start with you?
Sure. I think my overall point that I'd like to really leave people with is, remember to focus on the information that can be gained by the use of bracketing. It's really all about the information you can gain and the signaling that you can do to show that movement potential. And also keep in mind that if, you know, I think a lot of people have in their mind that bracketing is going to be used formulaically, in that, oh, there will be one bracket here, another bracket there, we'll have two counter brackets, and then we'll just end up at the mid of the mid. You know, it is rare that the bracketing unfolds that cleanly. And it, you know, because people move at different ratios to each other, among other reasons. But so bracketing can be messy, but I think the messiness of bracketing is really its superpower. It's why it's a successful technique. And another way to think about this is just that, you know, litigation in and of itself creates distrust, and that really it can obscure the path to a settlement that everyone could say yes to. And the reason it does this is because we have something called negative attribution bias, and that extends to questioning the opposing side's motivations as well as their willingness to compromise. So bracketing, I think, can be a really effective circuit breaker that can help the parties suspend or sometimes even forget that negative attribution bias, and it can reset and restart settlement negotiations.
And Tia, what about you? Last thought?
Yeah. So I think I want to give an example of the potential responses to a bracket. So when I was talking about the example where the plaintiffs came down to 750,000, and let's say the plaintiffs proposed that, and the defendant came up to 50,000, the four potential responses are: that bracket can be accepted by the defendant, in which case the status of negotiations is now 750,000 and 50,000, as opposed to the 1,000,000 and 20,000 that they were at before. The second potential is it can be responded to with another bracket, in which case, and back at the first one, it would be the plaintiff's go, right? The plaintiff proposed 750, the defendant on 50,000, the defendant accepted it. Now it goes back to the plaintiff, and they have to come off the 750. So you got to make that clear. The second potentiality is the defendant does not accept the 750 and 50 spread. They said, look, we don't feel comfortable coming up to 50. We could do 40, And so they may propose another bracket, and maybe that's good enough and maybe it's not. But say the hypothetical is if the plaintiff can come down to 750, we'll come up to 40. And in which case the defendant is now proposing the bracket. And if it's accepted by the plaintiff, now the defendant's going to have to move up off of 40. The third potential is kind of one that Patricia talked about, which is they say, not doing brackets, but I will come up to 35,000. You know, maybe they've considered the proposed bracket by the plaintiff. So your third potentiality is that the response is what we would call a firm number or a firm demand. And then the last one is that negotiations simply end. And you always have to consider that. And that's what we're talking about with the messaging and being careful. So I just wanted to go over that in more detail. It may have partially answered one or two of the questions, but we can follow up with that too.
Thank you. Kari, would you give any final thoughts you have?
Yeah, I was just going to say, you know, my final thought on bracketing is to remember it's just one of your tools. And you can leave it, come back, leave it, go back, go to something else, you know, discuss the facts, come back. And oftentimes bracketing is no different than going, look, if they go here, will you go there? Or telling, you know, the other side, look, the other side is saying they're really done unless you make a big move. It's just telling them what the big move is rather than expecting them to decide what the big move is. You're giving them a nudge by saying your big move is X. And if you make that big move, I'll come to this. And the other side may say no, but at least they've heard what you're willing to come to if they do make some big move. So it's never a fail. It's always just a tool. So there's no they worked or they didn't work in my book. Even if the bracket is accepted, it doesn't really matter to me whether it's accepted or not. It just keeps people moving forward rather than saying I'm packing up.
Right. I'm gonna some of these we've answered in part, but I'm gonna put those out here, put them out here for you all, and you can weigh in on the pieces I think we haven't quite answered on some of these. One of the panelists asked, or one of the audience members asked, please talk about the situations in which the mediator suggests the bracket. So the mediator is suggesting the bracket and what the risks of that are. And also talk about the risk of a room agreeing to a bracket and the other room rejecting the number to which it's asked to agree.
I'll go to that just because it kind of goes back to how I use bracketing. I think it is incredibly important that you really lay out the full process and each of those alternatives. I did it rather briefly when I talked about this, but because everyone does use bracketing and even the term bracketing differently, it's so important to define what that means. So if a mediator is proposing a bracket, you know, one thing that's unclear with that question is this in caucus where you're talking, see, I talk about ranges. If I'm talking in caucus and I want to introduce the idea of specific number ranges, I rarely do that because I like it to be driven by the parties. And I'm afraid if I put out a number, it will influence them in some way that may not be helpful. And so I really like making sure that the final numbers that are a bracket, which the way I use bracketing is only a number that the parties, you know, generate, and then I take to the other side. So I think part of it is being clear with what you're doing. If you're talking about ranges generally in caucus, you know, is that something that's confidential? Or, you know, what can be shared? And, you know, having all those understandings clear before you start out with your mediator, I think is really important.
Right.
And I will add to the last part of that was, you know, what happens if the bracket is proposed and then the other side says, yeah, we'll go within it. And, you know, the party that proposed the brackets needs to understand they will be next to go. So, you know, the way I do bracketing, that doesn't happen because they understand if they say yes, it's my turn. And I need to propose something within that bracket, singly or a different bracket encompassing that.
There was another question about how parties should deal with top and bottom numbers and how you changing those numbers as you go back and forth with brackets sends a message and preserves the bottom line.
I'll jump in and respond to that. And I think if I'm understanding Jennifer's question correctly, some discussion about how the parties deal with top and bottom numbers. So when you're crafting the proposal, I mean, you're trying to get an acceptance, but sometimes it doesn't work and you have to modify it. And keep in mind that in the course of negotiations, you might only do this once or twice. And as we've referred to, then you might go back to conventional firm number negotiating. So I think the way you should deal with it is by preparing and giving care and talking through the potentialities of when you craft your proposal. And if it's rejected, it's rejected. But that doesn't mean that something close to that can't work, or that, you know, another demand or offer that might come back that will be more meaningful. I think the goal is to have more meaningful and more productive communications and to try to avoid and minimize these overinflated values or overinflated demands, what Kari calls monopoly money, and undervaluing offers to settle that just drive the parties apart. So that's I hope I answered your question.
And then finally, there was one last question about, is it a good idea to think of possible brackets before the mediation? Which I thought was an interesting question.
Yeah, I mean, I think it's always good to think about that type of thing, but it's also really hard to do effectively because negotiations are very dynamic, and things that we discuss in, caucus may, the goal is you are trying to shift perspectives and you're trying to shift the way both sides are seeing their cases so that they can get to a yes. So I encourage doing it because I think it's a great way to practice. But in reality, you have to deal with the facts on the ground at the moment.
And I would just add to that, though, that as the lawyer representing a client, I think you're brilliant to think of the bracketing ahead of time, because you free up your client's thought process ahead of time that this is a negotiation. Just because I'm going to demand or offer X, it doesn't mean that's where we'll end up. And in fact, this is a negotiation. And the way we're going to do this is by trying to make the other side move towards us. And to do that, we have to start moving towards them. So it implies lots in that one conversation about getting you as the lawyer and your client in a collaborative space before you're even having to collaborate with mediators and with the opposing side.
Great.
I'm going to make one final point. I know we're at the end. And if the bracketing doesn't work, I think a kind of a little secret side benefit is it can give a lot of information to the mediator. And if the parties request a mediator proposal at the end, the mediator is in a much better position to offer something that has a higher likelihood of being accepted.
Great. Thanks so much, Tia. Thank you, everybody. And thank you so much for having us today, Sarah. We really appreciate the chance to be here and to share on this topic.
Oh, thank you, everyone. That was a wonderful presentation, super informative. Thank you all for taking the time to do this. To the attendees, thank you for attending today. There's some praise in the comments for this program. Look out for your attendance certificate and materials, like I said, in your email. And I hope everyone has a great rest of the week.
Absolutely.
Thank you.
Bye-bye.
Thank you, everyone.
Thank you guys for your praise.
Bye all.